Hello, my name is Chris Hill. I'm an attorney in Portland, Oregon. I run the site portlandinjurylaw.com, and this video is one of a series. This one is about tort law basics, the basic things that you need to prove when you prove an injury case. And there are three elements to just about every injury case. Those are liability, causation, and damages. And I'm excluding things like workers' compensation and some various other statutory schemes here. This is your basic injury type case, which would cover things like automobile collisions and also injuries on premises. And starting with that first element, liability, basically the first thing you need to prove is that the bad guy, the defendant, is legally responsible for the injury. And that can come from common law sources. So in the case of an automobile accident, that's going to be the common law duties of lookout, speed, and control. It can also come from statutory sources. Again, taking the automobile accident, that's going to be things like traffic control devices, lane change signals, that sort of thing. If you run afoul of the motor vehicle statutes, that can be a basis for proving responsibility. Of course, that also goes the other way as well. Part of liability is comparative liability or comparative fault. And the basic idea there is if you have two people or more who are potentially responsible for an injury, the jury may end up splitting up the responsibility between the two or more of them. So you may have a 50-50 split, 70-30, whatever the number may be. The second of the three elements is causation. And that's where you need to show the bad guy's bad conduct was a cause of the injury. It has to be a substantial factor, something which is material and not insignificant, in the words of the jury instructions. There can be other things which play into it as well. For example, if you have an underlying condition that gets flared up or aggravated, that is something the law allows you to recover. If you have a previous infirm condition which makes you more susceptible to injury, osteoporosis is the classic example of that, you can still recover for that. So for example, if you suffer a broken bone with osteoporosis when somebody else might not have, the law does still allow you to recover for that. The basic theory being the responsibility for that should rest with the wrongdoer rather than the person who has the medical condition. The third thing that you need to prove in order to prove an injury case is damages. In Oregon, we break those up into economic and non-economic. Economic damages is going to be things like medical bills, wage losses or earning capacity losses, property damage, and a whole host of other things that are listed in the statute. Non-economic damages generally fall into two categories. The first one is pain and suffering. And the second one is impairment and inconvenience to your normal and usual activities. Also less common, but is part of non-economic damages, is scarring and disfigurement. Non-economic damages, by definition, are difficult to put a dollar figure on, and they are not the easiest thing to explain and not the easiest thing for jurors to decide upon, but they are nevertheless part of reasonable compensation when you have an injury case. So that concludes this first video dealing with tort law basics and the three things that you need to prove in order to prove an injury case: liability, causation, and damages.